Please, yes. Lordship, I beg to mention for listing of a matter for motion, Lordship, transfer matter. Pursuant to your Lordship's order, my husband was brought to in my place of posting considering the well-being of son. Now I am being transferred. Lord. I have been transferred, not yet release order issued, Lordship. Lordship, kindly.
Lordship, my prayer for listing a case for today, Your Lordship. Here all the petitioner are technical officer, Your Lordship. Lordship's order on 11 December.
Yes.
Lordship, tomorrow is the date, Your Lordship.
No,
Time is
tomorrow. Today
9:30
not
to
possible.
10. There is a Lordship order, Your Lordship, on
Today not
11.
possible. There is a division bench in this case.
Lordship.
Mention it in another code. then.
Lordship.
Your Lordship.
Obliged, Lordship,
Sir,
tomorrow.
beg to mention item 17, Lordship. My senior has some difficulty today, Lordship.
Item 17.
Lordship.
For whom
Let me see.
petitioner?
Yes, petitioner.
As paid for by learned counsel for the petitioner, this matter stands passed over for the day. Yes.
After vacation,
Yes.
obliged.
Yes.
Lordship, I beg to mention the item number 14, Lordship.
Hmm.
Lordship, the engaged counsel for the petitioner, Mr. R. Borua.
What do you want?
Adjourn the matter for
On the
today.
prayer of learned counsel for the petitioner, this matter stands passed over for the day.
Obliged, Lordship.
Disability matter, similar matter, tomorrow, my lord.
May I please, Lordship, with the cause of the respondent, I beg to mention item number 23, Lordship.
Yes.
23. After vacation, Lordship.
On the prayer of learned counsel for the petitioner, this matter stands adjourned for a week.
Obliged, Lordship.
But please, Lordship, I beg to mention item number 33. Lordship, matter may be taken after vacation, Lordship.
On the prayer of Ms.
Zibora,
Zibora, learned counsel appearing for the
petitioner, Lordship.
petitioner, this matter stands adjourned and we now listed after the winter vacation.
Highly obliged.
Item 33.
33, Lordship. 33. Motion item 1.
Which order has been
Page
violated?
9, my lord, is the judgment order, my lord.
Yes.
Direction was given at the motion stage to consider the case of the petitioner for promotion. The quota was violated, my lord. 90 days time was given. Page 11.
Yes.
Nothing has been done, my lord. It is about 7 months, my lord.
Sponsor 8 weeks. Steps by step.
Item 2.
Format to run.
Please, Your Lordship.
Yes.
My lord, this matter is to compassionate appointment, my lord. The petitioner's father died on 13/2/2007.
All right, Ms. S.B. Chaudhary, learned counsel for the petitioner, peruse the amendments made in the writ petition. The matter pertains to prayer for appointment on compassionate ground. NOM 8 weeks. Who's appearing for whom? No government advocate today here in this court? Why government advocates are absent? Any reason? Is there a strike or something like that? Huh? Mr. Hendik? Ms. M. Bhattacharjee, learned additional senior government advocate Assam, has appeared and accepted notice on behalf of all the respondents. As such, service of notice is deemed to be complete in this case. Extra copies of the writ petition be furnished, requisite in number, so as to enable her to obtain this.
Petitioner is agreed with it is non-selection to the post of Gambura, Lordship, in spite of having the requisite qualification, Lordship, and the criteria stipulated in the advertisement.
Issue notice only. I heard Mr. Ganguly counsel for the petitioner, peruse the amendments made in the writ petition. The petitioner is aggrieved due to his non-selection for appointment in the post of Gaon Pradhan of charge number 14 of Pakka Moja under Sarthewari Revenue Circle in the Borpeta district. Issue notice returnable in 8 weeks. Since Ms. M. Bhattacharjee, learned additional senior government. Now, since Mr. J. Hendik, learned SC Revenue has appeared and accepted notice for respondent number 1. And Ms. M. Bhattacharjee, learned additional senior government advocate Assam for respondent numbers 2 and 3. Service of notice upon the said respondents is deemed to be complete. Extra copy of the writ petition will be furnished to the learned departmental council. Requisite in number, so as to enable them to obtain inspection. Petitioner takes steps for service.
Any orders that may be subject to the final.
4 by registered post to KD. It is obvious.
I will file today.
The petition is before the lordship, the non-release of the area salary as per 2017 ROP. My lord. At this stage, I am paying only for notice.
But Mr. S. Boral and counsel for the petitioner. The petitioner is aggrieved due to non-release of his area salary. For the period from
For the period from 1/4/2016 to 31/3/2020.
1/4/2016 to
48 months.
31/3/2020. You're appearing,
Lordship, I have
All the.
standing up for all the respondent lordship.
Mr.
T.R. Gogoi lordship.
T.R. Gogoi, Learned Standing Council, Assam
Assam State House.
State Housing Board, has appeared and accepted, prays for some time to obtain instruction in the matter, and on 8 weeks. Since Mr. So-and-so has accepted notice for all the respondents, no formal notice, extra copies.
Item 5.
Yes,
Lordship, petitioner serving the PWD department, Lordship, since 2015, Lordship.
Hmm.
Lordship, he has received salary, Lordship, page number 29, Lordship. Chief Engineer, PWD, Lordship.
heard Mr. A. Sharma and counsel for the petitioner, peruse the averments made in the writ petition. The case of the petitioner is that he is serving in the office of PWD
Roads,
roads
Lordship.
in the at Sipazar in the district of Mangoldoi, aggrieved due to non-payment of his salary. The
Lord.
petitioner is approached. Aggrieved due to non-regularization of his service and also
Lordship.
non-payment of his salary. The petitioner has approached this court by filing the instant writ petition. And on 8 weeks, who is appearing? You have served copy?
Lordship.
All right. Mr. R. Dhar, learned additional and understanding council PWD Assam appears and accepts notice for respondent numbers 1 to 4, 1 to 5. As such, no formal notice is required to send in this case extra copies, etc.
Lord-
This by showing the name of Mr. R. Dhar, learned SCPWD in the cause list.
Lordship, pendency of the case, Lordship.
Yes,
No,
we
no,
did.
but. March.
Item 6.
Please.
6, 7 and 45. Madam.
Those covered matters.
Yes.
6, 7 disposed of. Who are, give the appearance. Who is appearing for whom? 6 and 7.
Lordship for Health Department.
All right. 6 and 7 disposed of. Yes.
6, 7 and 45. 45 also.
6 and 45.
6, 7 and 40.
Yes.
Supplementary test for motion item 36.
Lordship, it is a covered case. Lordship, the similar order at page 52, Lordship. Lordship, petitioner belongs to ST category.
Yes.
If it is covered, Lordship,
You have to tell us.
no,
if
Lordship,
it is-
because it's not allotted to me, that is why I have no the petition. So
Where is the order? Where is the previous order?
Page 52, Lordship, page 52.
Petitioner is ST.
ST, Lordship.
Disposed of, page 50, 53, 54. As an order to cycle, changes in posture available. Disposed of. Obviously.
May I please, your Lordship?
Yes.
Lordship, in this case, the respondent number 2 issued advertisement for appointment of additional notary, page 35, my lord, is the advertisement.
What is your case?
My case is, my lord, we have also applied, but neither our case has been rejected, not recommended, only private respondent
Right.
has
But
been called.
why have you all come together? Anyways, heard
My lord,
Mr. M.R. Khandekar, learned counsel for the petitioner, perused the amendments made in the writ petition. The writ petitioners herein had submitted their candidature for appointment as additional notary public for the district of South Salmara, Mankachar. They are aggrieved due to the fact that none of them have been called to appear in the interview process. Mr. Khandekar submits that there are serious irregularities in the selection process which requires to be interfered with by this court. First, Ms. M. Bhattacharya, learned additional senior government advocate Assam, appearing for the state praise for some time,
For only one lordship.
sometime to obtain instruction. Issue notice of motion returnable in 8 weeks. Since Ms. Bhattacharya has accepted notice for respondent number 1. District judge will be SC Guwahati, is it? Guwahati High Court. And Mr. H.K. Das, learned SC Guwahati High Court for respondent number 2. Service of notice is deemed to be complete on the said respondents. Extra copies of the writ petition be furnished to the learned departmental counsel. First to enable them to obtain instruction. Petitioner to take steps for service of notice upon respondent numbers 3 to
25.
3 to 25 by registered post with AD within a week from today.
My lord, till no result has been published, nothing, no selection, my lord.
Part of the prayer of interim relief, having regard to the facts and circumstances of the case, it is hereby provided that selection of additional notary public pursuant to this process
Shall not be
undertaken by
finalized.
the authorities shall be subject to the final order that may be passed on this case.
I am on.
Order still vacated, I can wait.
May it please your lordship, madam. My lord, in item number 8, my lord, there is another item in supply, item 38. This is filed by respondent number for 6 and 7 for stay vacation, my lord. Lordship may like to take up this or along with item number 38, my lord, because there is a note in the supply list to take up along with item number 8.
Who has filed this IA item?
My lord, I have filed this IA, my lord. Respondent number 5 in the writ petition. My lord, here the interim order is 21/12/2020.
Which number?
Page number 72, my lord.
My lord, I am for the writ
Relevant
petitioner.
portion is
The
page
stay vacating
76.
petition I have received just now, my lord. It was
Ah.
served. It was served to my clerk, so just now I
We
have
have
received it.
already
my lord.
served. My lord, here the writ petition as per the affidavit filed by the government, writ petition was not found within the zone of
This
consideration.
IA was filed when?
My lord, IA we filed, my lord, no, we have given, so far this is copy is concerned, we have already given, my lord.
No, you have given, but it shows 1812.
1812.
Yes. Yes.
So he is entitled to a reasonable time to file. You want to file objection?
My
Yes,
lord,
my lord. Yes, my lord.
my prayer,
Please go to the, let them file their objections.
What is there in no notice?
Yes, my
You
lord.
file
Fine.
objection. means-
my prayer is for, my lord, for early disposal of this matter, because 2020 order now, after 3 years, they have implemented. Although we have promoted, my lord, we have reverted back to the original post. They have made a wrong statement in the writ petition. They're saying that at the time we did not join, whereas from the documents we annexed, my lord. So therefore, my lord, we already joined and they made a wrong submission. On that basis, the interim order given.
No, my lord.
So my
not on
lord,
that
no,
basis.
page para 12, 20.
Let him
Yes, my
finish.
lord.
Why don't you take your seat?
Yes, my lord.
There is a chair.
Yes, my lord.
Is it comfortable?
No.
Take
Para-
it.
Para 20 of the writ petition, my lord, they said that we did not join, but whereas we already joined. On 25/11 we joined, order was on
Where is
21/12.
the interim order? You said, where is the order?
Interim order is page 76, my lord, relevant portion. Having
This
regard to
this
the.
order is of
Yes.
2020.
Yes, my lord. Because, my lord, by the next page, my lord, page 77,
Hmm.
my lord, this is of dated 12/12/2023.
Hmm.
Now they have reverted back in view of this order, my lord.
Hmm.
So, my lord, I pray for a fix that on reopening, my lord, let them file objection. We do not have any objection. My prayer is for a fix.
No objection to objection.
My lord.
Yes, what to do? How much time you need to file objection?
My lord, because one of the petitioner, he is in Sibsagar, so we need some time, at least
Huh?
3 weeks time, my lord.
Stay vacating, it can't be 3
My
weeks.
lord, the stay order was of year 2021 and the
2020.
2020, and somehow they managed to suppress all the stay orders, my lord, in the office. Now it has come to the light of the authorities and they have passed this reversion order. Otherwise, it was to be passed immediately after passing of the interim order.
I
my
would
lord.
not have prayed, my lord, if the government
Is
had
the
not said,
reversion order under challenge?
this is not under
Yes, my
challenge,
lord.
this order is.
You
pursuant-
take any date, the IA will be dismissed.
My lord.
You have to challenge, it's a separate.
reversion order.
My lord,
It
this
is
is
not a reversion
pursuant to
order.
the interim order.
It is said our promotion is state.
Yes.
It is not an order.
Pursuant to the order dated 21/12/2000.
All right, I have Mr. BK, the counsel for the applicant. This
No.
IA has been filed with the prayer to vacate the order dated. vacate-
21/12,
modify
madam.
The order dated 21/12/2020. By the learned single judge in WPC number 5282 of 2020. First of Mr. DP Boral and counsel for the writ petitioner opposite party submits that a copy of the IA has been served upon him very recently and therefore he will be granted 3 weeks time to file affidavit stroke objection. Mr. KP Pathak, learned standing counsel.
I am appealing for the application. Item number 38.
Mr.
It is
In view of the
accepted,
prayer made by
seven.
Mr. Bora,
Time
time is granted to the opposite parties writ petitioners till 8th of January 2024 to file their objection, if any. Registered to list this case again on 12/1
My lord, deeply obliged.
as a fixed item.
My lord, in the meantime, may I make a prayer, my lord?
Interim order passed earlier to continue till then. Yes.
They have filed one IA, my lord, wherein they have, my lord, prayed for MACP, not the promotion. So they are not giving us the copy of the IA, my lord. I request that.
My lord, they have appeared now. My
No,
lord,
no.
they received a notice, my
So
lord.
you give it to him now.
I
Yes, my lord,
already
I
requested,
give
my lord. My lord.
Give it to
And-
him.
Praying for
and-
transport department.
Acha,
and for-
and I add koribo, Miss MD Bora.
In view of filing of the MACP,
is also present.
It does not have.
And you are in item number?
38 here. There are two IAs in 30. I don't know.
Item 38, Mr. KP Pathak. Same order. You
Same
want-
order.
So same order.
Same order.
Same order, list along with item 8. Baki sab ek hoga. Khali instead of Mr. BK Das, like Mr. KP.
Deeply obliged, obliged.
Yes.
It's a
Who's there?
contempt matter, but standing council, animal husbandry and veterinary department has been shown in the cause list. That's why I'm your lordship. Please.
No, but the applicant is not there.
Applicant is not there, my lord.
Then we'll have it after vacation.
Lordship.
One appears for the applicant on call. Is M. Kotoki, learned SC, AH and veterinary department Assam has appeared since her name is shown in the cause list. Be that as it may, due to the absence of the applicant's counsel, this matter stands passed over for the day.
Obliged, lordship. For admission, I can tell.
Yes, Mr. Das.
Lordship. The matter pertains to the termination from the post of chowkidar, petitioner. Thereafter, what happened, my lord, this honorable court
on 4/11/2015, passed an interim order paying the impugned notice of termination. And thereafter, on 11/11/2016, yes, in ISU number 1486, the respondents were directed to, pay the salary within a period of 6 weeks from the date of receipt of certified copy of the order. That was also not, complied with. So there came the contempt. We filed a contempt. That is contempt case number 54, 2017. Yes. And the IN number 1311 of 2017. Your client is continuing in service? No. No. Where is the interim order? Interim order, my lord, will find it. In the contempt case itself, my lord. Page 6, Annex 1. So there is some review petition in this? Yes, they file a review petition. So, and another petition, that is IA number 1311 for application for vacation modification of the interim order dated 4/11/2015. So is ex-serviceman welfare society a party to the writ petition? Yes, yes. Respondent number? My lord. 7. 7. Who's appearing for respondent number 7? One item number? 10. Where is Mr. N. Borwa? Can you ask him to come and take up the matter? I'll try and see. Yes, because his name is shown, otherwise again they'll come with a review petition. After some time, okay.
Lord, on last occasion, respondents short time to file affidavit, my lord, including the private respondent.
Yes, who's appearing?
Lordship, I am appearing for the department, Lordship. We already have written, but we are seeking a 2 weeks more time, Lordship, to file the affidavit.
And who's for the private respondent? Yes, last chance. We'll give him 4 weeks, but last chance.
Lordship.
All right, heard Mr.
Will
G.
be
Bhakti
filing.
and counsel for petitioner. Also heard Ms. M. Bhattacharjee, learned additional senior government advocate Assam appearing for the respondent numbers 1 to 4, who prays for one more opportunity to obtain instruction and file affidavit. None has appeared for the respondent number 5, although the name of the council is reflected in the cause report. Be that as it may, on the grounds stated by the learned government advocate Assam and on her request, this matter stands adjourned for 4 weeks so as to give one final opportunity to the department to file affidavit, register to list this case accordingly.
Date may be fixed, my lord.
Huh?
Date.
Date will be in February then.
Yeah.
Register to list this case again on 12th of February 2000.
Briefly only.
Obliged.
May I please, Lordship? Case is regarding a relaxation of age.
Maybe
Sorry, my-
the Lordship. Lordship, we need some time to file our affidavit, Lordship, in the matter. The petitioner has already been allowed by this,
Yes.
by virtue of this court's order,
Or-
Lordship.
By
to take
order,
part in the
ordered it,
selection
So
process.
he is continuing now.
Lordship, results has not been declared.
Result is not.
As
But
he
he
has
has
been
already
allowed to
participated in the
take part-
entire-
participate.
Lordship.
As per High Court honorable.
So let her file affidavit then.
Fine.
Heard Mr. G. Pathak,
G. Pathak.
counsel for the petitioner. Also heard Ms. P. Sharma, and standing counsel appears,
Respondent 3, 4, and 5.
appearing for the respondent numbers 3, 4, and 5. Top is R. Borwal, and counsel is present for the respondent numbers 1 and 2. Ms. Sharma submits that on the strength of the order of this interim order of this court, the petitioners have been allowed to participate in the selection process, but the results are yet to be declared. The learned SC APSC therefore seeks 4 weeks further time to file affidavit. Prayer allowed, but the matter be listed upon the.
Obliged, Lordship.
Okay.
Item 13.
Matter relates to disciplinary proceeding, Lordship, and on the last occasion on 9/11/22, Lordship, notice was issued. So reply is necessary, Lordship.
You are appearing for whom?
My lord, all the respondents, my lord.
Would you file affidavit or not required?
My lord, your lordship may be kind enough to give 4 weeks time.
Mr. G. S. Sharma, learned D. J. Sharma, learned counsel is present for the petitioner. This matter pertains to initiation of disciplinary proceeding against the petitioner and imposition of penalty
Penalty,
upon him.
Upon-
Is it major penalty?
major penalty.
An imposition of major penalty upon him.
First, it was the removal, my lord. Then they filed an appeal. His honorable court has said that it should be considered. Then he has been reinstated in the initial stage of appointment.
Penalty is reduction of pay to the lowest post.
And the
Major
charge,
penalty of reduction of pay to the lowest
post.
scale. Mr. C.C. Datta, learned senior counsel listed by Mr. S. Datta has appeared for all the respondents and seeks 4 weeks time to file affidavit. Prayer is allowed. This case again after 6 weeks. In the meantime, parties to exchange pleadings.
much obliged.
Obliged, Lordship.
Otherwise, pleading complete, Lordship.
None appears for the petitioner on call. Ms. B. Sharma, learned CGC submits that this matter is ready as regards pleadings and can be taken up for disposal after the winter vacation. In view of the above, admission hearing of this case stands adjourned. Is taken after winter vacation.
Item 16.
May I please, Lordship? Well, petitioner before all retired as a casual fourth grade or fourth grade casual worker from the office of the fishery district officer.
When did the petitioner retire?
Lordship.
Petitioner retired when?
Yes, 34/2018, man.
And when was the judgment passed in Upendas?
Yes, that is 8/6/2017. And in terms of that order, she is entitled from 1/8/2017 to 34/2018.
Yes, who's appearing? You're appearing?
Preparing for the finance department, my lord.
Hmm.
But as per order dated 26 June 2020, my lord, it is a parent department who is capable of releasing the, my lord. releasing the, my lord, amounts, my lord, not the finance department, my lord.
Which is the?
It is the fishery department, my lord.
Is there a standing council fishery?
Yes, my lord, there is a standing.
Instructions. So, excuse me. Our name is already in the list, serial number 45. 49, no? There's a list we have prepared, 77. So total number 77 that we are going to consider. And his name is already there under serial number 49. So it is, doesn't make only see this instruction. So we are not taking into account that he has retired just before the decision has been taken by the government. Perhaps he will be considered.
Then what do you have to say? What do you have to say?
My lord, it is not the finance department, my lord. It is the fishery department who will release the.
So you are agreeable to this. He is saying she is entitled to, because the decision was taken.
Objection, my lord. But it is the parent department who is going to decide, my lord. And we will have to find an.
All right, we'll dispose it of. Yes, your name, please?
K. Raman.
Heard Mr. K. Raman, learned counsel appearing for the writ petitioner. I've also heard Mr. C.K.S. Borua, learned government advocate Assam, appearing for the respondent numbers
1, 3, 4, and 5.
1, 3, 4, and 5. Miss R. Borua. Please.
Respondent, my lord.
R. Borua, P. Borua.
R.
R.
Borua, my
Borua.
lord. For respondent.
Learned counsel is appeared for the finance department, that is respondent number 2. Full stop. The facts of the case lie in a very narrow campus. Full stop. The writ petitioner herein was initially engaged as a grade 4 casual worker under the establishment of District Fisheries Development Officer, Mangaldoy, Darang on 8/1/1986. Full stop. She continued to serve as a casual worker on fixed pay and retired from service on attaining the age of superannuation with effect from 30/04/2018 after rendering continuous and uninterrupted service for 31 years and 2 months. Full stop. At the time of her retirement, the petitioner was drawing fixed pay of rupees 9,000 per month. Full stop. After the order passed by the division bench of this court in the case of State of Assam versus Upendas and others, third bracket, writ appeal number 45/2014, the Finance Department of the Government of Assam had issued notification calling for list of casual employees from the administrative departments for the purpose of extending the benefit of within course minimum of pay scale,
Yes.
unquote, of rupees 15,000. You don't know.
Minimum pay scale, it is 12. Page
Oh,
136.
you don't know. Give me the figure. What is the amount minimum pay scale?
12,000. 12,000.
No, he doesn't know. He's not aware of the facts. After vacation. What is the minimum of pay scale as per Upendas's case?
Yes, my lord, it is decided page 136 and except 2, my lord. Kindly have a look, my lord, 136 page.
Minimum of pay scale
Lordship, the pay scale is
notified by the Government of Assam on 8/3/2019. If it is wrong, then your client will suffer. Prior to that, a list was called for from the administrative departments, including the fisheries department, and the name of the petitioner appeared at serial number 45 of the list dated
My lord, 49, my lord.
49 in the said list as eligible casual workers entitled to the benefit of minimum of pay scale. Minimum of pay scale as fixed by the government. First of. However, in the meantime, however, before the list could be implemented, the petitioner retired from service. First of. Contending that the decision of the government to implement the order of the division bench rendered in the case of state Assam versus rendered in the case of Upendas was taken on 1/8/2018, and therefore the petitioner would be entitled to the arrear amount as per the said decision for the period from 1/8/2017 to 30/4/2018.
Yes.
Full stop. Hence this writ petition. On instructions from the department, Mr. C.K.S. Barua, Planet Jia Assam has produced a copy of the written communication dated 22/8/2023, issued by the Joint Secretary to the Government of Assam, Fishery Department, which goes to show that the petitioner is entitled to the benefit of minimum of pay scale for the period claimed by her. First, Ms. Borua, learned SC Finance Department submits that if the petitioner is entitled to the benefit, the department would not have any objection to her prayer. First, taking note of the submission of learned counsel for the parties, this writ petition is being disposed of with a direction upon the respondents to examine the claim of the petitioner in the light of the observations made herein above and take necessary steps for releasing the arrear amount as due and payable to the petitioner under the standing government circulars as under the order of the division bench in the case of Upen Das Supra, as well as the standing government circulars. The aforesaid exercise be carried out within 3 months, within 90 days from the date of receipt of a certified copy of this order. A copy of the communication dated 22/8/2023 be written in the record of this case. Writ petition stands disposed of.
Obliged.
Standing also finance department. I'm not the standing also, madam.
Then I'll penalize accordingly.
I am sorry, my lord.
After vacation, nothing. to-
Only my non-appearance partner.
No, it
Yes,
will be
my lord.
appear. Sorry. These things are-
But I was on like in another court, my lord.
You did not appear, so you did not appear.
I can understand. Anyway.
Pass
public.
the order, yes.
Lordships, our instruction is here. We seek 2 weeks time to file our affidavit.
Mr. D.P. Voral and counsel is present for the petitioner. Mr. I. Botakur and counsel for the
Forest Department.
Forest Department submits that instructions have been received and the same will be placed on record within 2 weeks by filing an affidavit. Ms. P. Burwa, Ms. R. Burwa is present on behalf of the respondent number 8. On the request of Learned Department of Counsel, this matter stands adjourned for 3 weeks in order to enable them to file affidavit. List accordingly.
May I please, your lordship?
Yes.
We have received the instruction, my lord. We would like to file the affidavit, man.
Miss
J. Akhtar. J. Akhtar.
Day after, Learned Counsel is present for the petitioner. Mr. S. Datta, Learned SC PNRD Department Assam submits that he has received instructions and therefore be given 3 weeks time to file affidavit. Prayer allowed, this case again after 4 weeks.
Hello, hello.
May it please your lordship. Matter has become infractions, lordship.
Mr. R. Sharma, Learned Counsel for the petitioner submits that this writ petition. Why it has become infract?
So I challenge the result of preliminary exam of the APSC, lordship. Main exam was also over.
Now interview going.
Mr. R. Sharma, Learned Counsel for the petitioner submits that not only the preliminary examination, but even the mains examination of this CCE conducted by the APSC is over, and therefore the writ petition has become infectious. Ms. P. Sharma, learned SC APSC, and Ms. A. Talukdar, learned G. Assam are present on behalf of the official respondents. Taking note of the submission of Mr. Sharma, his writ petition stands disposed of as infectious.
Actually, the respondents are required to file their affidavit.
But in this case, as instructed Mr. Gagoi, my lord, he has filed the affidavit, my lord, that
Which respondent, you are appearing for whom?
higher education, my lord.
Your lordship, that affidavit was filed, but on the last occasion on 11/10/2023,
Hmm.
they have submitted the respondent number 4, that is a secretary is required to file an affidavit in this case.
Why? Director has filed affidavit?
Your lordship, director has filed their affidavit because director has sent a proposal to consider our enhancement of pay, and that is pending with the government. So the government will take a decision or not, that is to be, and he's representing the secretary also, your lordship.
Who is appearing for the finance department? Mr. Arsenal and counsel has appeared for the writ petitioner, Mr.
S. Das, my lord.
S. Das, learned SC, Higher Education Department. Submits that affidavit on behalf of the respondent number 6 is already on record. Ms. A. Talukdar has appeared for respondent numbers. Ms. A. Talukdar, learned G. Assam is present on behalf of respondent numbers 1 and 3. 1, 3 and 4. Any affidavit is required?
One only one.
Commissioner and Secretary Higher Education.
No, I will be appearing, my lord.
Sure.
For higher
One.
education.
The Learned Standing Council Finance Department represented through Ms. R. Borua, Learned Council has prayed for 3 weeks' time to file affidavit. In view of the above, let this writ petition be listed again after 4 weeks. In the meantime, parties to exchange pleadings. Yes.
Deeply obliged, your lordship.
What's it 23 loss?
23 is yet to come. Wait till the station reaches.
Very distance I am running solo.
Oh, you have to take rest.
What's it? 23 my I think. 22.
This is 22.
22.
This is 22.
What's it? For the timing loss.
Wait, let him. No. Yes, yes. You want some water? Do you want drinking water? Give him some water, somebody.
My lord, please.
Yes.
Madam, relating to my lord, comparison appointment method. SHC madam illegally rejected my candidacy madam on the ground that my late submission madam. Where is madam? My father died on madam 23/3/2017 and I applied for madam on 11/9/17. It was reflected in the DLC madam. DLC recommended my name. But SHC rejected on the ground that my late submission madam.
Where is the resolution of SLC?
SHC madam 20 page 22 madam. CL number 22 madam.
Ria Bora, is it?
Madam Ria Bravo.
Yes.
Page 17 is the madam DLC madam resolution madam.
All right, late submission, what is it?
Lordship, the decrease, date of the decrease is the 23/3/17, but application has been done on 17/5/19, so almost
No, madam.
2 years gap. That is.
No, madam, 11/9/2017 madam.
No, it is, sir. Yeah, no, date of submission of application. 7/5/19.
No, he says, application is 11/9.
Page 15 madam, kindly have a look at it. Page 15 madam.
Checklist for appointment.
Page 15 madam. This is application madam, original application. This is all received madam. All supportive documents are enclosed here with me. With application.
So what is the delay? Where is the delay?
There is not the
Event in this, it 19 হয় জানো?
What
Seven-
event then?
19 হয় জানো?
17.
His father died on 23/3/2017. And he
Father
applied
died
on
for 23/17 and applied my on
6
11/9.
6 months. What does the OM say? Where is the OM?
Page
Where is the OM which has been relied upon?
on page 25.
Yes. Can you show the relevant part? As far as time is concerned, where is it mentioned?
In various High Court order, it is.
Where is the time mentioned in this OM? Mr. Borua?
Lordship, এক বছৰ কথাটো লেখা আছে নহয়? So there is a period of 1 year mentioned in the.
One bottle of water and glass here always. Anybody may need it. It's out. Yes.
Lordship, point number 3, Lordship. In
number
his
3.
petition, this page number 26.
Yes.
Every eligible dependent seeking appointment under this OM shall make an application for appointment on compensation grounds in this prescribed form with all enclosure within 1 year from the date or acceptance or retirement of the employee with consent letter of the retired employee. In case of missing government servant, a request to grant the benefit. That is, basically, it is also 1 year as part of OM.
So it has been done within 1 year.
No, Lordship, the checklist that we have been attached with our various comments, which shows date of submission of application for appointment is 17/5/19. Date occurred in 2017. So there is a gap of 2 years. Lordship, as per this checklist that we have.
Then you file affidavit. You have to file affidavit then. Because the application date is September 2017. You file affidavit then. Who will file affidavit?
SLC, Lordship.
SLC.
Take down, heard Mr. Kanikal and counsel for the petition also had Mr. C.K.S. Borwal, government advocate also appearing for the state. After the premature demise of the father of the petitioner on
23/17.
23/3/2017. The father of the mother of the petitioner applied for appointment on Actually, this application is by mother.
No, not mother applied for me, my lord.
Why? You were a minor.
No, my lord, I am not.
Why mother applied?
At the time, my lord, mother. Page 15, what is the, please. But according to my lord, application, she is minor, my lord, Horuswali. But she passed SSA exam.
Then it can't be. Recently, there is an order of the court. It can't be. That till you can't submit an application as a minor. That's, you examine the order then.
Madam.
You see.
I'll verify.
You write so and so, so and so. Mr. Konikor seeks posting of this matter again after the BU vacation. Ensuing BU vacation so as to examine the orders passed by this court pertaining to claim for appointment on compassionate ground made on behalf of minors and address further argument is accordingly.
Diploma.
In this case, my lord, though I am receiving my lord, family pension, my lord. But GPF is pending and my lord, DCRGS, my lord. This regard, my lord, they have already recently, my lord, one letter was issued, my lord. Returning the said amount, my lord. I have annexed here that letter also, my lord.
Yeah, who's appearing for the department?
Lordship.
Who's appearing for the department?
I am appearing for Accountant General. On 17 October 2023, Accountant General reissued the GPF Final Payment Authority to the Executive Engineer Tihu Division. Now it lies on the DDO and Treasury Officer Patsala, Lordship.
Yes,
It is a department.
of course you are, that's what is your stand? The AG has already cleared it.
Yes, my lord.
Then
This is now it is pending in the Treasury Department, my lord.
who is appearing for the Treasury Department? Nobody is responding.
Finance.
Treasury is finance. Treasury is finance.
For this, my lord.
No, I have not included.
Yes, my lord.
Actually, you have not even implemented Treasury
Yes, my lord.
Finance.
Director of Pension. It was.
Then you have to wait, Mr. Das. This is a lapse. Why don't you, when you want money, you don't implement the finance?
This, no.
Hmm.
Director of.
Take down, I heard Mr. H.K. Das, non counsel for the, H. Das, is it?
H. Das.
H. Das, non counsel for the writ petitioner. Also heard Miss D.S. Neog, learned SC Irrigation Department, Assam, appearing for the respond numbers 1, 2, and 5, 1, 2, and 4, and Mr.
KK Medhi appearing for respondent number 3 on behalf of.
And Mr. S.K. Medhi appearing for the respond number 3. First up, the writ petitioner is aggrieved due to non-release of his complete retirement dues. Mr. Medhi has produced a copy of the order dated 17/10/2023 issued by the Office of the Principal Accountant General bracket A and E bracket close Assam to submit that necessary approval for withdrawal of the GPF dues has already been issued to the Treasury. And therefore, it is now up to the Treasury officer to do the needful. However, I find from the record that neither the Finance Department nor the concerned Treasury officer has been implicated as party in this writ petition. Full stop. In view of the above and for the ends of justice, the Secretary to the Government of Assam, Department of Finance, as well as the Treasury Officer of Barpeta.
Yes, ma'am.
Patsala.
Patsala has a Treasury Officer.
Yes, Lord.
Yes.
It's a subdivision.
Bojali
Now
district.
Bojali district.
Bojali district.
Treasury Officer of Bajali District.
Patsala sub treasury.
Patsala Sub Treasury are hereby implemented as respond numbers 5 and 6 respectively. Writ petitioner to file amended cause title within 3 weeks from today. Issue notice to the newly implemented respondents, Miss Borua, Miss R. P. Borua, R. Borua, learned counsel has appeared and accepted notice for respond numbers 5 and 6 and prays for 3 weeks time to obtain instruction. Prayer allowed. Let this matter be listed again after 4 weeks by reflecting the name of Learned Standing Council Finance Department, Assam in the cause list. You have a look at this. Yes. Pendency of this writ petition shall not be a bar for the authorities to do the needful for redressing the grievance of the petitioner.
May I please, Lordship?
Hmm.
Lordship, affidavit in opposition already filed, Lordship. We need some time to file in.
Your name, please?
Deka.
C. Dekan and counsel appearing for the writ petitioner prays for and is granted 3 weeks time to obtain instruction and file rejoinder. in response to the counter affidavit filed by the department. Mr. C.K. Gora, Learned G. Assam, and Ms. D.S. Nino, Learned SC Irrigation Department are present on behalf of the official respondent. Please take order.
Item 27, 32.
My lord, in item number 27, my lord, and item number 40 to 43 of the supplementary list. In these matters, my lord, we have been terminated from service after issuing the so-called notice, my lord. We have submitted our reply, and since our reply found unsatisfactory, my lord, we have been terminated from service. And my lord, in this regard, my lord, I'd like to, my lord, place on passed by this honorable court, my lord, wherein, my lord, it was held that since we have issued the so-called notice, we have to follow the procedure. Without following the procedure, it cannot be terminated from service, my lord.
And what about the other cases?
Other cases, my lord, a notice have been issued, my lord, and my lord, I am praying for that judgment of Surojit Burman passed by lordship, my lord.
Hmm.
That no notice was issued on the basis of clause 9, we are terminated. And the lordship has already in person judgment, which is annexed to the writ petition, my lord.
So which are the other matters? Item number?
I have appeared for 29, 28.
Which are the other matters? Item 28 to?
Yes, I appear, my lord, 28, 29, 30, 31, 35 matters, my lord. In these matters, my
And
lord,
supplemented 39, my lord.
and no shock was issued, my lord, in these matters. 28 to 32 and 39.
39 supplementary.
Six items, my lord. No shock was issued, my lord.
In these cases, no show cause notice issued.
No
Yes,
shock
my
was, my lord.
Contextual employee, no so-called notice issued, the reason has been recorded. And my lord, we have been terminated.
In my item, my lord.
So is there any interim? You wait.
Okay.
I know you are here. We'll hear you. You are visible.
Interim order is not there, my lord, because we have already been terminated. Contract agreement has already been terminated, so no interim order was passed, my lord.
So in the first group, which is 27, 42, and 43,
Yes, my lord.
here show cause notice has been issued.
Issued, my lord, we have submitted our reply.
Hmm.
After submission of our reply, my lord, since our reply they find not satisfactory, they are terminated from service by applying the clause 9 of the agreement. But as on that, there is no agreement, my lord. The agreement was executed for 1 year.
Hmm.
And thereafter, we are allowed to continue in service with all service benefits. Thereafter, my lord, the
No,
so-called.
but that will amount to auto renewal of agreement.
Yes,
Contractual
ma'am.
service cannot be without the
But
agreement.
the agreement was for 1 year. That is why I make this submission, my lord. And
Mr. Dekar,
yes.
you must be very clear on what are you arguing. Agreement is not extended. That means your service is over.
But that was not the ground, my lord, for my termination, my lord.
Be very sure what you are arguing.
Yes, yes.
These are
So this is the
legal
issue, my
matters. Huh?
This is the issue. First batch of case with notice, and the second batch
Let's see
without.
27 and 42 and 43. First we'll deal
Yes,
with
ma'am.
these matters. 27 is here and 42 and 43.
40 to 43, my lord.
Yes. So who you are appearing in 27?
Yes, my lord.
Who
From
is
20,
appearing in 42 and 43?
I am appearing, my lord.
Acha, and only these three cases are in one category
Yes, my lord.
where show cause notice
Very issued, my lord.
were issued. And then after that, your client submitted reply
Yes, my lord.
and then they terminated the
Terminated from
services.
service.
Now, which is the clause they are relying upon? You refer to item 27.
27 clause 9, my lord. Lordship will find it page 19. The impugn order. No, sorry, man. Not page 24 is the impugn order, man. I'm sorry, man. Second last paragraph, man.
What is clause 9?
My lord, kindly turn to page 19, my lord. This is the annexure.
Hmm.
This is the agreement, my lord. There
Which
is no
page
clause 9, my lord.
There is no?
Clause 9 is not there, my lord, in this agreement.
May I answer, madam?
Yes.
Madam, this document is of the year 2009, madam.
Hmm.
And this is supposed to be for a period of 1 year. If we see at page 21, madam, para E, it is clearly stated, the engagement shall be made for 1 year and it may be renewed annually. Moreover, my lord, this agreement is not signed by any officer of the panchayat.
Forget that. Where is clause 9?
There is no
Your
clause
officer
9.
is relied upon
Because of the
clause 9.
current year, my lord,
Ah.
subsequently the format, the form, model form, my lord, that was adopted, my lord. And if we,
Where is that document? Where is
if
that
we have a
clause?
look at the other, the
Hmm.
if my lord will have a look at the item number 42, my lord, there the agreement is there, my lord.
No, in case of the writ petitioner, in item 27.
In item number 27, my lord, that has not been annexed by the petitioner, my lord.
So where is the agreement in item 42?
42, my lord.
Page number?
Page, my lord, annexes C, page 21 onwards, my lord.
Item 42, the clause, page 22, my lord.
Page 22, clause 12.
Clause 12.
12, man. 12
Okay.
actually deals with termination of clause, although the reference that is made over there, it's of a different clause, man.
Then the order goes.
But we don't have the exact agreement that has been entered into with the. That's the reason, because even this is
He
of
didn't
the.
have a case till you started arguing. Now he has a case.
Sorry, my lord.
If you would have kept quiet, the writ petition would have been dismissed, but now it will be allowed. You have given him the handle. You don't know which is the agreement. That agreement does not have clause 9. Clause 9 does not deal with termination, and yet that is non-application of mine. That is his case. There is no application of mine in this case.
My lord, the ground.
We have to interfere with this order,
My lord, the
Mr.
order may be, order may, the impugned order.
Because the clause 9, and if the clause, we'll go by law. We are not interested in anything else.
My lord, we kindly.
If the clause permits this, and if it is done according to the clause, that's the end of the matter. We'll dismiss the writ petition. Otherwise, we'll allow it. But you want a conference now?
No, ma'am.
And we'll record your submission.
May I submit, my lord?
Yes, yes. Hmm.
What happened, my lord? These employees are, my lord, earlier the format of model format was different, my lord. And there were other clauses for termination. And after the expiry, my lord, those agreements are not enforced, my lord. Now, although they are continuing, my lord, present current year model format, my lord, we are approaching, my lord. So they have not signed the agreement, the renewal, but we are following the current model format only, my lord.
Very well. Now you are giving them a ground.
My lord.
So you file an affidavit.
My lord.
We'll take it up immediately on
Yes,
your
sir.
opinion.
I can
File
file it.
affidavit covering all these matters.
My lord.
And which clause, which agreement has been?
Yes, I
relied
can
upon?
model form agreement, I can annex, my lord.
Yes, but they will have to be signatory of that agreement. Otherwise, the order will be bad.
My lord.
If you rely on an agreement.
Model
which-
agreement, my lord, not signed by the petitioners, my lord.
Correct.
Yes.
But where is clause 9?
Clause 9 in current modern in the 2023 model agreement, clause 9 is there, my lord, for termination.
So they'll have to file affidavit.
Yes, we can file agreement, my lord.
Heard Mr. R.M. Deka as well as Mr.
দাদা আপনার নাম।
আপনার নামটো? You are appearing. কোনটোত কোনে appear করে just give it. Huh? So then you have terminated without notice.
Yes, my lord.
How can you do that?
Yes, my lord. For that, my lord.
No, this order has been passed in 27, 42 and 43.
My lord, my lord.
Mr. R.M. Deka, Lorry counsel appearing for
Yes,
the
yes.
petitioner in this batch of petitions who submits that the order of termination issued in respect of each of the writ petitioners is dehorsed the contract agreement and therefore is liable to be set aside by this court. After going through the materials on record, it is not clear as to which provision of the contract agreement has actually been relied upon by the departmental authorities to terminate the services of the petitioners and on what ground. So at this stage, Mr. S. Datta, Learned Standing Counsel, PNRD Department, Assam, prays for 3 weeks' time to file an affidavit, bringing on record the facts, including the model agreement, which would be applicable in case of the writ petitioners. On the request of Mr. Datta, these writ petitions, 27, 42, and 43, be segregated from the other writ petitions and listed separately. Again on when can you file the affidavit? You file it by 5th. We'll have it on 10th.
My lord.
10th of January 2024. Affidavit on behalf of the department be positively filed on or before 5th January 2024 by serving advance copy upon the Commissioners Council.
My lord.
Now we give the other batch.
For the other batch, my lord, I want to rely on judgment of our.
Other batch is 28, 29, 30, 31, 32, and 39.
39 months old.
Yes.
My lord.
Yes. So in all these cases, services were terminated without
Yes.
Without notice.
notice.
Lord.
So it is covered under the judgment.
Lordship, no, I have submitted one judgment, my lord. It's covered under this judgment, my lord. Clause, paragraph 9 and 10, my lord. You can answer last time.
Answer.
Madam.
Nine.
But there is another judgment which says. if you
That
make a-
judgment, lordships passed by, my lord.
Yes.
That judgment, there is specific stigma, my lord, from our department. That, my lord, some involvements are there, my lord, for those petitioners.
Here there is no.
Here, there is no specific, my lord. Only one paragraph of our clause, my lord, we have extracted, my lord. As they were arrested in those cases, so it's embarrassing for the department. There is a clause, my lord. And I want to rely this judgment also, one judgment I have just submitted, my lord. From I have lordship is reading WPC.
They are all
622.
computer assistants.
My
This
lord.
item 28 to 32 and 39,
Yes.
they were serving as computer
Assistant
assistants.
come computer operator.
Computer. Gram Rozgar Sevak is also, Sahayak is also there.
No, but how can you terminate services without notice?
My lord, that another judgment I have submitted, my lord, of our High Court, my lord. Lordship is reading WPC 462/23, my lord. I am relying paragraph 9 and 10 and WPC 724 of 2007. Isn't it well? I'm sorry, it's a computer downloaded copy, my lord.
No, that's all right. That's
Yes,
all right.
paragraph 14, my lord.
Just 1 minute. Where is the judgment of this court?
My
That
lord,
next, my lord.
my
That
lord
is
is finance item number 39, my lord.
Oh, I can't go on all this. Give me a copy.
Wait a day, my lord.
32, 39, can't go on shifting from one page to another. Mr. Dekha, you should have prepared a
Yes,
bunch
my
of
lord.
papers and given it to the court.
I have annexed it, my lord.
Whatever order I'll pass, I will only look at the record of this case.
Yes, yes, my lord.
If it cannot be done, we'll adjourn it. It's not possible to look for item 32, then for another document, item 39. In a bunch matter, is not possible. So this judgment is of 1/6/2023. And this is of 14/8. So this is prior. This
This is
judgment is prior.
1/6/20.
Lordship judgment is prior, but that is the difference, my lord. That lordship judgment, that the termination order, my lord, the specific stigma is there in that case, my
What
lord.
is the specific stigma? Let us see.
My lord.
Item 39. Rokibud. Rokibuddin, Rokibud.
Yes, page 8, my lord, of that judgment, my lord, last paragraph.
1 minute, 1 minute. So there is a conflicting view in two orders.
My lord, that John Soikia, my lord, John Soikia, no?
Yes.
Yes, John Soikia judgment has already been considered by this honorable court in a order. My lord, can kindly peruse it, my. I beg to rely upon paragraph number 7 and 10 to 12. In a similar facts, my lord. There also, my lord, they were embarrassed, my lord, because of the arrest of the petitioner, paragraph 7, where it is relied, my lord, by the, that order was passed, my lord, on 18/9/2023. Yes, lord. Paragraph 7 and 10 to 12, my lord.
Paragraph 7 and
10 to 12.
so in this judgment, Sailendra Bora, this decision was not considered. Ali Ahmed Barbuya was not considered. But the view taken is same as Ali Ahmed Barbuya. But John Seika's view has been.
Slightly different, man.
But the point is, these are two conflicting views of coordinate bench.
Yes, my lord.
It should go to a, what is the way forward in
My
this
lord,
matter?
before passing the judgment, my lord, in my humble submission, John Soikia, my lord, that judgment has already covering the field. And in that case, my lord, instead of passing this order, my lord, the matter may refer to the larger bench. Yes. And
Then you argue on that. It can't be just done. You argue on that.
John Soikia, my lord, in my respectful submission, my lord, John Soikia is my lord, par imperium, my lord. I beg to place to judgment passed by this honorable court in full bench, my lord. One is Yogodis Dekar, who is reporting in 2014 5 GLR page 43. Oh, yes. For facts, my lord may kindly peruse paragraph 8, 9, 10, 11, 12.
Jagadish Deka.
Jogodis Deka, my lord.
Paragraphs 8, 9.
Paragraph 8 to 12 for facts, my lord. May I read, my lord?
Yes.
One writ appeal being writ appeal number 112 of 2010, which arose out of WBC number 6468 of 2007, was heard first in point of time by division bench consisted of Justice Ranjan Gogoi and Justice BP Kotogir. This division bench, by its order dated 21/5/2010, dismissed writ appeal number 112 of 2010 and upheld the writ court's orders dated 9/4/2009. The other division bench consisting of Justice A.K. Goyal, Chief Justice, and Justice Ujjwal Bhuyya, after 3 years of the disposal of writ appeal number 112 of 2010, heard another writ appeal, being writ appeal number 154 of 2009, which arose out of WBC number 6182 of 2007 against the same order dated 9/4/2009. By order dated 19/10/2012, this division bench, without noticing the earlier division bench order dated 21/5/2010, passed in writ appeal number 112 of 2010, allowed the writ appeal 154 of 2009, and while setting aside the order dated 9/4/2009, granted relief to the writ petitioner which he had claimed in his writ petition. Then came a third matter. It was heard by another division bench comprising of Justice A.K. Goswami before the division bench. A bunch of 5 writ appeals being writ appeal numbers 158, 159, 160, 161, and 160 of 2009, all arising out of same order dated 9/4/2009 were listed for hearing on 29/11/2013. During the course of hearing, the aforesaid two conflicting orders passed by two different division benches referred above were brought to the notice of the bench. If the contention of the learned counsel for the appellants in their support was that all the 5 appeals should be allowed in the light of the later decision of division bench rendered on 19/10/2012 in writ appeal number 154 of 2009. The contents on learned counsel for the respondent state while opposing the appeals was that all the 5 appeals should be dismissed in the light of earlier decision rendered by division bench on 21/5/2010 in writ appeal number 112 of 2010. The division bench, that is what the reference order, my lord. Can I go to paragraph 16, my lord?
Yes.
At page 47 of the judgment. Paragraph 16.
Yes.
In our considered opinion, the question number 2, 3, and 4 need to be decided in keeping in view the principle of rule of par incurium and binding precedence of the decisions rendered by the same court on the same issue. Indeed, these principles were the subject matter of several decisions of the Supreme Court and remains no longer re integra. It is therefore apposite to take note of the decisions on this subject which explain its true meaning, effect, and consequences. Thereafter, my lord, the Supreme Court judgments were taken into consideration, my lord. Now, my lord, kindly turn to paragraph 24. At page 49. Down below. In our considered view, since appeals, writ appeal number 112 of 2010 and writ appeal number 154 of 2009 arose out of common order passed by the writ court on 9/4/2009, both these appeals, including others arising out of same order, should have been heard together on merits in accordance with law. Secondly, since all the writ petitions were decided by common order, which suffered their dismissal, the appeals arising out of such order too should have resulted in passing of a common order either way, unless any individual appellant was able to point out any distinguishing feature of his case from the bunch of its separate hearing. Thirdly, once a decision was rendered by one division bench in one appeal arising of common order, a fortiori such decision was binding on another division bench, whether consisting of same judge or other, to avoid passing of two conflicting orders in one case. Fourthly, if for any reason the later division bench did not agree to the view taken by earlier division bench, then it had no option but to refer the matter to a larger bench, full bench, to resolve the conflict after setting out the reasons for their disagreement and the area of difference. Fifthly, the later division bench had no jurisdiction to decide the appeal on merits by taking contrary view, except to follow the reasoning and conclusion arrived at by the earlier division bench. And if they formed an opinion to take contrary view, then it was obligatory on the division bench to make a reference to a larger bench to resolve the conflict. Sixthly, the jurisdiction to take a contrary view and obligatory declared decision par incurium was with the full bench on a reference made by the later division bench. And lastly, since no one brought the earlier decision to the notice of the later division bench, a situation had arisen where a judgment came to be passed which is in conflict with the earlier division bench judgment. Next, 25. It is for these reasons we are considered opinion that the decision dated 19/10/2012 rendered by the division bench in 154/2009 is par incurium. In the second one, my lord, paragraph 7 and 8, my lord. The judgment in a later case, page 601.
Yes.
Paragraph 7, the judgment in a later case can be described as par incurium decision only when a binding verdict for a similar case is ignored by the court. But when decisions are rendered in different factual contexts, the disregarding of the ratio in earlier case cannot be said to be a par incurium decision. I am relying on the first paragraph, my lord. In appropriate and similar circumstances, respect for an earlier judgment should be the norm, but exceptions are permitted in deserving cases where the facts are dissimilar and parties are governed by different terms, applying the same verdict would result in unequal treatment. Therefore, when a decision is reached on different facts, previous decision cannot be described as false or inferior decision where the court is confronted with another situation where parity or judgment will not be warranted.
So, Mr. Datta, you will have to first argue and satisfy this court that why the decision in the case of Jan Seika should not be held to be a judgment par incurable.
My lord.
This is first.
Yes,
If you cannot satisfy,
yes,
then the matter will go to a larger bench.
my lord,
If you can satisfy, then we'll see whether it is distinguishable on
my
facts.
lord, my lord.
So are you ready to argue today?
Yes, my lord.
Today you are ready
Yes,
to
I'm
argue?
ready.
Then we'll
My lord.
reassemble. And where is the decision of Ajay Kumar Haloi?
Yes, my lord.
Is that there on record?
Ajay Kumar Hello is a little bit different, my lord. Ajay Kumar Hello case, my lord, during the contractual period, my lord, he was terminated. Thereafter, court observed that as the termination period is already over, so jurisdiction is not for him, my lord.
Termination period is over means?
My lord, there is a 1 year contractual period, my lord. In between the contractual period, he was terminated. Thereafter, during the pendency, my lord, his contractual period is already over. That is the Ajay Kumar Haloi case, my lord.
So both of you are ready to argue on this all legal aspects today? I will not
I have-
adjourn it. That's what I'm saying. If you are ready, you do it.
I'm otherwise ready, but
After vacation, my lord, I have relied on this judgments. After
And we'll have it on 4th January.
my lord, 4th January.
4th January. The items will be 28, 29, 30, 31,
or
32,
5th January maybe, my lord, Thursday, hearing day, my lord.
5th January is not Thursday. You are looking at the wrong calendar.
Oh, sorry, my lord.
I'm sorry, sir.
Sorry, my lord. Yes, yes.
4th January, Thursday.
Oh, yes, yes. Sorry, my lord.
Mr. R.M. Decca and Mr. Kadir, Mr. MJ Kadir. Also have Mr. Ed Dr. Lanet and Mr. Devnath, Lanet Standing Counsel, appearing for the PNRD Department. This, you are appearing. Is A. Aludar Lanet GSM is present on behalf of the state. The core issue involved in this batch of writ petitions is as to whether the writ petitioners who are engaged as contractual workers, now writ petitioners who are serving as contractual employees under the respondents, as to whether these services, the contractual services of the writ petitioners would have been terminated without serving any show cause notice or giving them an opportunity of being heard in the matter. The aforesaid issue has been answered by this court in the case of Ali Ahmed Barbuya versus State of Assam and 6 others. Third bracket WPC number 2977/2023, wherein it was held that it would be mandatory upon the departmental authorities to serve show cause notice and give them an opportunity of being heard, since the order of termination attaches a sense of stigma. Similar view has been taken by the learned single judge of this court in the case of Kailandro Bora versus State of Assam and 2 others. Third bracket WPC number 6680/2020. However, in the case of Jan Seika versus State of Assam and others, third bracket WPC number 4632/2023, a completely different view has been taken by the learned single judge, wherein it has been held that there would be no requirement for service of show cause notice before terminating the service of the contractual employees. Full stop. It further appears that the decision in the case of Jan Seika Supra was rendered without considering the decision in the case of Ali Ahmed Borbia bracket Supra, which was rendered prior in point of time. Be that as it may, all the employees, all the contractual employees involved in the aforesaid writ petitions were serving under the Panchayat and Rural Development Department, and their conditions of service were governed by more or less identical conditions in the contract agreement.
Yes.
Full stop. If that be so, it is apparent that there are conflicting decisions of this court on the aforesaid issue, which may have to be resolved by referring the matter to a larger bench. However, before arriving at, at this stage, Mr. Datta submits that the facts in the case of Jan Saikia Supra is distinguishable and therefore seeks one more opportunity to address the court on the above aspect of the matter. In view of the request made by the learned departmental counsel, registry is to list these cases again on 4th of January 2024 as 6 items for admission hearing. Parties to come prepared accordingly. Come up with some decisions.
My lord, my lord.
Highly obliged.
If you could not find Mr. M. Burwa, in spite of my best efforts.
Then we'll fix it immediately on reopening, and on that day, if he is not present, then we'll pass adverse orders. Otherwise, they'll come for review again.
2015
Mr.
matter,
Ekedas,
Lordship.
yes,
It's a 2015 matter, I mean. He's
that's
suffering.
right. But
Petitioner is
Mr.
suffering.
Ekedas, learned counsel appearing for the writ petitioner, also heard Ms. M. Bhattacharjee, learned GR, additional senior government advocate, Assam, appearing for respondent number 3, and Ms.
Ishwar Gary, correspondent 1 and 2. On behalf
P. Sarwari, learned CGC, appearing for respondent numbers 1 and 2. None has appeared for the respondent number 7, although the name of Mr. N. Borua, learned counsel, is reflected in the cause list. It appears that the relief as prayed for by the petitioner can be, if granted by this court, can be enforced by the respondent, can be enforced, can be implemented by the respondent number 7. Full stop. However, the learned counsel for the respondent number 7 is not. It appears that order granting relief, if any, to the to the writ petition can be implemented by the respondent number 7. However, despite the fact that the name of the learned counsel for the respondent number 7 is shown in the cause list, he has not appeared to. In view of the above, for the ends of justice, and so as to give one more opportunity to the respondent number 7 to appear in the matter, this writ petition is directed to be listed again on 8th of January 2024. It is made clear that if the respondent number 7 does not appear, even on the next date fixed, this writ petition will be taken up for disposal on the basis of materials available on record.
Obliged.
Yes.
Lordship, hereby silence the post of the respondent number 4, that is the senior advertisement is page number 34, Lordship. That the senior assistant, Lordship, have silenced the post.
Challenge the post.
Yes, Lordship.
How can you challenge a post?
Who is junior than me, your Lordship? Can you please annexary page number 34, your Lordship?
First you clarify, how can you challenge a post? You're challenging promotion.
Yes, Lordship, challenging
Why are you saying
promotion.
challenge the post?
Challenging promotion, Lordship, who is junior than me, Lordship, and the advertisement itself violation the criteria, Lordship.
Achha, what is the matter? Just a minute, I'm not understanding. it. What is the
Lordship,
matter?
his grievance is that his junior to him has been promoted, Lordship.
Promoted as?
Junior assistant.
No,
Oh, head
senior-
assistant, Lordship,
head-
senior assistant, from junior assistant to senior assistant. We have received instruction, Lordship. We may be allowed time to file the affidavit in this matter.
Let the affidavit be filed then.
Your Lordship.
But Mr. M. Saikel and counsel appearing for the writ petitioner, by filing this writ petition, the petitioner is assailing the promotion given to the respondent number 4 in the post of head assistant on the ground that by ignoring their seniority, the respondent number 4 has been promoted in violation of the rules. Ms. M. Bhattacharjee, learned additional senior government advocate Assam, appearing for the respondent numbers 1, 2, and 3, and he submits that she has received instructions and therefore be granted 4 weeks time to file affidavit. Mr. S. Datta, learned counsel for the respondent number 4, has also prayed for 4 weeks time to file affidavit. In view of the prayer made at the bar, this writ petition is directed to be listed again on 2nd of February 2024 as a fixed item, so as to enable the respondents to file affidavit in the meantime by serving advance copy upon the petitioner's counsel.
Thank you.
Deeply obliged, Your Lord.
Any next orders?
May I please, Your Lordship? I appear for the sole respondent, Your Lordship. The order has been complied, Your Lordship.
None
I will be
appears
allowed
for
to place the order, Your Lordship.
None appears for the petitioner. Mr. A.K. Das, learned counsel.
A. Das, Your Lordship.
A. Das, learned counsel for the sole respondent, appears and submits that the order of this court has already been complied with. In support of his above submission, Mr. Das has produced a copy of the minutes of the SLC meeting held on 7/9/2023.
Second page, serial number 3, Your Lordship.
A perusal of which goes to show that the case of the petitioner was considered, but the same has been rejected.
Recommended, Your Lordship.
It's the same as serial number 3.
3, Your Lordship. Ritudas Chaitya, Your Lordship. Decision of the SLD down below, Your Lordship. Page number 2 of the bundle, Your Lordship.
Has been considered and has been recommended for the post of constable, bracket DGCD.
And there is also an order on the last page, Your Lordship. The name of the petitioner is at page serial number C, Your Lordship.
Consequential order dated 6/11/2023 has also been issued, wherein the name of the petitioner finds place. If that be so, it is apparent that the order of this court has been complied with. By retaining a copy of the resolution dated 7/9/2023, the record of this case, this contempt case stands closed.
Obliged, Your Lordship.
Case for the petitioner.
What is this IA for?
My lord, we have to reconstruct the file, my lord. We don't have a copy of the file. It's a 2013 matter. As per records, my lord, petition number 1 has expired, my lord. IA is about removing the name of the petitioner number 1 in the main petition.
So what do you want now? You want the court record?
No, my lord, we want to reconstruct the file, my lord.
None appears for the applicant when the matter is called up. Ms. R. Burwal and a counsel appearing for the departmental authorities submits that since it is an old matter, the file has been displaced and therefore some time will be required to reconstruct the file for responding to the prayer made in the IA. In view of the above, this IA be listed again after 4 weeks.
Deeply obliged.
Yes. Order complied with?
Complied with.
Mr.
I'm
S.
placing
Das,
the-
learned counsel for the petitioner is present. Mr. H. Sharma, learned counsel appearing for the respondent numbers 1, 2, 3 submits that the order of this court has been complied with. Mr. Sharma has also produced a copy of the
The last page, Lordship. In accordance with direction on the first place, Lordship, this is done. Next, January per month.
January.
Copy of the order dated 19/12/2023 issued by the Secretary to the Government of Assam Cultural Affairs Department. It goes to show that provisional pension of the petitioner has already been granted. Granted. Yes, so the
I can give him a copy. And that may be kept as a part of the.
My lord, small provision is there, my lord, 1 month salary, that is February 2020.
that can't be
That is
gone into.
Lordship in the contempt
My
proceeding that
In
cannot.
view of the above,
Representation
said-
was submitted.
a copy of the communication dated, order dated 19/12/2023 in the record of this case, the contempt case stands closed.
Much obliged. আজি মানে
Over.
treasury
What
সোমাই
about
গৈছে।
45?
মই খবৰ ল'লে গম পাম।
Yes.
Appeal has been dismissed.
Dismissed.
Obliged.
I agree.
So in this matter, we have found that charge against Abbas Ali, Abdul Ghafoor and Abdul Hai could not be established under 149 or 34. Therefore, criminal appeal 362 of 2017 has been partly allowed by acquitting these three persons, but the other appeal is dismissed and conviction of Sajan Fakir, Abdul Malik and Abdul Haq have been affirmed.
I agree.
Obliged.